Would you agree with me that when you prepared this affidavit that it was clear that Kouri Richins was a primary suspect of your investigation?
No, I wouldn't agree with that statement.
You would not?
No.
You didn't think she was a suspect at this point?
I didn't have definitive information that she was a suspect.
In a dramatic twist in Kouri Richins' case, her defense team is accusing the lead detective of perjury, citing alleged contradictions in his testimony. They argue that his errors could have a major impact on the case, and with a life sentence on the line, we're going to break it down for you as the legal battle intensifies ahead of her trial set for April. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. Kouri Richins' defense team is requesting a new hearing, claiming that a key detective perjured himself during a recent pretrial hearing. The legal battle has been a dramatic turn as defense attorneys for Richins argue that the testimony of the case's lead detective was inconsistent and inaccurate and potentially undermines this whole case. So Richins, who was arrested in May of 2023, she is accused of murdering her 39-year-old husband, Eric Richins, on March 4th, 2022. Prosecutors allege that she administered a fatal dose of fentanyl to Eric. She's also facing charges over an alleged attempt to poison him just weeks earlier using a sandwich laced with a similar substance. And here's where things get really interesting. So in the months leading up to her arrest, Richins wrote a children's book about grief, a project that many found chilling considering the circumstances surrounding her husband's death and now what she's accused of. But last week, Richins' defense team, led by attorney Wendy Lewis, filed a motion asking the court to reopen questioning of witnesses. You see, the defense claims there were issues with Detective Jeff O'Driscoll's testimony, specifically his recollection of events when he took the stand, and this was at a recent pretrial hearing on January 23rd. So the motion seeks to question 4 additional witnesses and review cell phone and electronic data. In their filing, Lewis cited the United States Supreme Court case of Giglio v. United States, which mandates that prosecutors have to, by law, disclose evidence that may undermine the credibility of a prosecution witness, impeachment evidence. So to understand why this is so significant, let me just take a quick look back at Giglio v. United States. So in 1966, you have a man named John Giglio. He was convicted of passing forged money orders. But his defense later discovered that prosecutors had failed to disclose a key fact, that the witness against him had been promised immunity in exchange for his testimony. That would be very important to know, right? Goes to credibility. Well, the Supreme Court ruled that this failure violated due process as it was critical to the witness's credibility, and the case set the standard for Giglio information, Giglio material, which requires the disclosure of any evidence that could call into question the honesty or the credibility of a state witness. Now, I got to say something here, a little sidebar from Sidebar. I think it's fair to say that the stories we cover show you that the world can be, pretty dangerous, unpredictable, and you need to protect yourself. And that includes protecting yourself online, particularly your personal information, whether it's spam, identity theft, online stalking. Our amazing sponsor, Surfshark, offers an incredible solution to these issues with their alternative number feature. So this service, built right into the Surfshark app, lets you create an entirely new identity, complete with a random U.S. phone number, email, name. This way, you can keep your real number and details completely private. It's great for signing up for services or websites that maybe you don't fully trust, ensuring your personal phone number stays free from spam. Also, with alternative number, you don't have to give your real phone number to strangers while shopping on various marketplaces. So if you're ready to take your online privacy to the next level, check out Surfshark in the description below or visit surfshark.com/alt-sidebar. Sign up now and get Surfshark's alternative number feature plus 4 extra months of Surfshark. So now we go back to Kouri Richins' case. And her attorneys are raising concerns about Giglio material, Giglio information regarding Detective O'Driscoll's testimony. Specifically, they make the argument that O'Driscoll made mistakes, made errors in handling the statements that Richins had made to him during his visit to her home on April 14th, 2023. This was before her arrest. And that those statements should now be suppressed as evidence, meaning they shouldn't come in to her trial. Now, additionally, they argue that the prosecution has to disclose further details about O'Driscoll's interactions with Kouri Richins, as this information could impact his credibility as a state witness. Now, during the pretrial hearing that I mentioned before, the defense pointed out several contradictions in O'Driscoll's testimony. One key issue that they highlighted was his claim that he didn't consider Richins a suspect at the time, despite having applied for a search warrant for her phone and computer just one day before the visit. Actually, I'll tell you what, let's go back to that January 23rd hearing and break it all down for you. So O'Driscoll testified that his visit to Kouri Richins' home was part of just a routine introduction after a change in her case management, and stated that he wanted to meet her in person and establish contact.
Detective O'Driscoll, I want to turn your attention to and discuss your interaction with the defendant on April the 14th, 2023. Do you recall that day?
Yes.
At that point in time, what was your relationship with this case?
I had just been assigned as the lead investigator on the case. I was not familiar with all the details of the case. I was trying to get a fresh perspective and pretty much starting from scratch.
And as part of your start from scratch, did you want to introduce yourself to the defendant?
Yes, I wanted her to know that there had been a change, not only in the assignment of the lead investigator on her case, but there had been some supervisory changes to the investigations division as well.
And when you say her case, you mean the case at that point in time investigating the death of Eric Richins?
Correct.
What was the change to not only you as the lead investigator, but you said, I think, the supervision of the division?
There was a new sergeant over the detectives, the investigation division, Sergeant Hoffmeyer.
So I take it you determined to then personally call on the defendant on April the 14th, 2023.
Correct.
And why personally instead of over the telephone?
It had been a year since Eric's death. I felt it was more professional considering the loss that she'd gone through in the family, and felt that it was more appropriate to show up in person to speak with her and to introduce myself than over the phone.
Okay. There came a time then when you appeared on the doorstep of the Willow Court home where she was then residing. Is that correct?
Correct.
And thus began your interaction with her on that day, right?
Yes.
Did you record that interaction with her?
Yes, I did.
How did you record it?
I had a audio recorder running, and then later I activated a body cam that I had with me.
Okay. Let's talk about the body camera. When did you activate it?
After we were invited into the home and asked to sit down.
And did you activate it roughly contemporaneously with the point on the body cam, or the point on the recording where you say, "Do you mind if I record this interview?" or something to that effect?
Correct.
But according to the defense, the recording of this interview is a pivotal piece of evidence, because while Detective O'Driscoll claimed that he recorded the conversation with Richins' knowledge, the defense argues that he also brought a second recording device that Richins was unaware of, something that we'll actually delve into a little bit later. But we also learned during his testimony that O'Driscoll wasn't alone during the visit. We had another officer, Chad Hoffmeyer, was with him as well, and Richins' mother was also present. O'Driscoll described Richins as cooperative, even cheerful, emphasizing that the meeting was meant to be informal. But the defense contends that the conversation lasted several hours, pointing out that what was supposed to be a casual introduction quickly turned into an intense interrogation.
The intent to go to the house was not solely to get an interview. It was mainly to introduce ourselves and the change that had happened with the Eric Richins death investigation.
How long would that have taken?
I'm sorry, how long would what have taken?
An introduction.
Not long.
Okay, how long were you there?
3 hours.
Right. Okay, so before you went to her house, isn't it true that the day before you went to her house, you had applied for an affidavit for a search warrant of her phone and a computer?
I'm not 100% positive on dates.
Your Honor, can I approach?
Yep.
Can you go to the last date, the last page of the affidavit, and tell me the date that you executed it?
Says executed on 13th day of April 2023.
The day before you interviewed Ms. Richins, correct?
Correct.
And in this affidavit, you have multiple pages of why you want to search her phone, right? It looks like basically two pages of facts to support your affidavit,
Yes.
single spaced. And in this affidavit, you refer to things that happened on the night of Mr. Richins' death and things that Kouri had told detectives before you. Is that right?
Yes.
And things the toxicology report had recorded, right?
Yes.
So the defense points out that an introductory conversation with Kouri Richins ended up lasting over 3 hours. And as the defense dug deeper, they noted that the application for the search warrant for Kouri Richins' phone had been issued the day before the interview, filled with very specific details, suggesting a strong lead in the investigation, that this was more than just casual. And this led them to ask, if O'Driscoll really wasn't considering Richins as a suspect at the time, why did he have so much information about the case and even apply for a search warrant?
So before you interviewed Kouri, you had enough information about the case to prepare a 2-page affidavit with specific facts that had happened in meetings with Detective Woody, right?
Enough for this affidavit, apparently, yes.
Would you agree with me, sir, that in this affidavit it is extremely clear that Kouri is a primary suspect of this investigation?
I would have to take time to read the whole thing to answer that. I
Please
can if
do.
you want me to. No, I wouldn't agree with that statement.
You would not?
No.
You didn't think she was a suspect at this point?
I didn't have definitive information that she was a suspect.
Okay. But you wanted to look in her phone, and you were asking a judge to let you look into a phone, right? Her phone.
Correct.
And you're asking to look into her phone, by your own words, to see if she tried to obtain fentanyl on her phone.
Yes, that's the part that's recalling my memory is at that time, with the limited information I had, the most important fact that I felt we knew was that Eric died of fentanyl overdose. So the biggest question to me was how the fentanyl got into his system. And in my opinion, there were basically 3 different ways that Eric could have died of a fentanyl overdose. It could have been an accidental overdose, it could have been a suicide, or it could have been a homicide.
Now, another major issue brought up by the defense in Mr. O'Driscoll's admission is that he recorded the interview with, as I mentioned, that additional audio recorder, but failed to inform Kouri Richins about it. And while he did have a body camera visible to her, the defense really focused in on the fact that he didn't mention that audio recorder. And this became a key point of contention during questioning.
All right, so you show up, you don't tell Kouri that you just applied for a warrant to search her private information. Actually, what you tell her is that you all coach soccer together or something? Is that what you said when you came on to the house?
Your Honor, let me kind of renew this objection. What he told her is documented in audio and video recording. There's no dispute. It's not a game of gotcha. It is what it is.
Are you just trying to jog his recollection, lay foundation, or can we just move on?
All 3.
Okay, thank you.
Can I just get him to answer that one question? You talked about the fact that you all had ties in the community through soccer coaching and things like that, right?
Correct.
And then maybe she knew your wife or something?
That sounds familiar.
Okay. But you didn't tell her you were investigating her for homicide at any point in those 3 hours?
No.
You also didn't tell her you had a hidden recorder on your person, did you?
It wasn't.
Can you be specific at which
Yes.
point in time you're talking about?
When you first arrived at her house? Thank you, Your Honor.
No, the intention was not necessarily to hide it. The audio-only recorder was brought as redundancy in case of failure of equipment technology.
Where was it?
In my pocket.
Okay. Did you tell her
It
there
wasn't
was-
visible to her.
Right. Did
But
you
my
tell-
intent was not to hide that I was recording her.
Okay. Did you know whether Sergeant, it's Hoffmeyer, right, that was with you?
Correct.
Did you know whether Sergeant Hoffmeyer had a hidden recorder on him?
So our memories have been a bit confused on this point. Originally, I thought I had remembered that he had the recorder. The recorder was his piece of equipment and tools, but I think after listening to the recording from how far away he sounds from the microphone, I think I had the recorder on me, but it was just the one audio recorder and the one body cam.
Now, regarding the audio recorder, it is of course important to mention that this may not really be a gotcha moment for the defense, because the detective revealed earlier in his testimony that he also had a body-worn camera with him that he placed well within Richins' view when he was speaking with her, so he wasn't necessarily trying to do something sneaky with the backup audio recorder that was supposedly obscured from view, right? The idea would one record something that the other wouldn't. But it's this next portion of the questioning where it gets really, really interesting, because the defense is arguing that the detective really didn't testify truthfully about key details from his interaction with Kouri Richins. They assert that in his effort to show up and, as they argue, interrogate her, O'Driscoll made several critical mistakes and misremembered important facts during his pretrial testimony. One of the main points of contention is his claim that he didn't know Richins had retained an attorney at the time of his visit. So to highlight that, the defense walked him through a transcript of his interaction with Kouri Richins. Take a listen.
When she invited you in, did you Mirandize her?
No.
Right. Did you know she had a lawyer?
No, I did not.
You did not? All right, let's look at the transcript for just a moment. I believe it is number Exhibit 11 in front of you. And can you go to page 7? Can you read what Kouri said to you on line 3 of page 7?
So my attorney has been pushing to, obviously we just wanted her off the case because we're not getting anything done, anything accomplished.
And who's she talking about wanting off the case?
I think she was referring to Detective Woody.
So minutes into your meeting with her, she advised you she had an attorney.
Yes.
And you knew that you were going to elicit information from her that could be used against her, did you not?
I didn't know what information she would provide. I just wanted to know the facts surrounding the night of his death.
If she had said, hey, I killed my husband, would you have used that against her?
Likely.
Okay. So you didn't Mirandize her at that point. You knew she had a lawyer. You knew you were looking for information about her involvement in her husband's death, and you did not Mirandize her, correct?
Correct.
So it appears Driscoll said he didn't inform Richins of her rights, which of course raises another serious question. Was this a custodial interrogation? Should her Miranda rights have been read to her? The defense argues that since she was questioned for over 3 hours and wasn't told she was free to leave, the statement she made should be suppressed, again, meaning shouldn't come into evidence because she wasn't Mirandized. If her rights weren't properly explained, the defense contends that everything she said during that time should be excluded from the trial. Now, in general, Miranda rights are required when a person is subjected to custodial interrogation, meaning when they are in custody or not free to leave, they're being questioned by law enforcement officers. If someone is just casually questioned in a non-custodial situation, such as their home and they're free to leave at any time, Miranda warnings may not necessarily be required. Now, the issue here seems to revolve around whether Richins was in a custodial situation when Detective O'Driscoll questioned her at her house. If she wasn't told she was free to leave, or if the questioning was coercive or restricted her freedom in some way, then perhaps Miranda warnings would likely be required. Now, if she wasn't informed of her right to remain silent or have an attorney, her defense could argue that any statements made during that questioning should be suppressed as evidence. The complexity really comes in determining whether she was in custody, because that is a key factor in deciding if the Miranda warning applies. Now, as for the argument surrounding Richins' attorney, the prosecution contends that the Sixth Amendment right to counsel, that hadn't attached yet to Richins' case because there were no formal proceedings, such as an indictment or an arraignment. They hadn't begun. and Richins was arrested 3 weeks after this interview on April 14th. So there is something to that. There is case law to suggest that the Sixth Amendment doesn't attach until a suspect actually becomes a criminal defendant. But what I will say is this. The defense is primarily focused on the truthfulness of O'Driscoll's testimony. Did he lie or did he perjure himself, right? So if so, the defense would argue that they have the right to use this information for cross-examination and to challenge his credibility. Summit County Chief Prosecutor Brad Bloodworth was quick to respond with his own filing, dismissing the defense's motion as, quote, a cheap litigation trick. In his filing, he defended Detective O'Driscoll, asserting that the detective had testified truthfully and without malice. Bloodworth specifically wrote, defense counsel's feelings do not matter, objective facts matter. And he also pointed out that an independent review of the discrepancies by outside attorneys found no evidence of misconduct or dishonesty in connection with the detective's actions. And in his written response, Bloodworth urged the judge to deny the defense's motion, arguing that the detective was being asked to recall details that were not only insignificant, but occurred nearly 2 years earlier. Now, in a statement to local affiliate KUTV, his office said the detectives involved in the Kouri Richins matter have always conducted themselves ethically and testified truthfully. The defense's motion, filed last night, suggesting otherwise, is grounded neither in fact nor law. The motion's suggestion that a particular detective testified untruthfully is irresponsible. The state will respond fully in the record at the appropriate time, as provided in the rules. It is highly unfortunate that the defense in this case repeatedly chooses to malign individuals instead of focusing on substance and evidence. So now, to add on to all this, filings from the prosecution's opposition argue that the defense's approach is, quote, nothing more than defense counsel's latest implementation of current and former defense counsel's long-standing strategy to publicly malign honorable people to influence potential jurors. Now, Richins' defense team has fired back against this opposition, accusing prosecutor Bloodworth of using faux outrage to deflect from underlying issues raised by the defense. Part of the defense's response reads, the prosecution's faux outrage is utterly bewildering, as they are the ones who felt compelled to make the disclosure. That disclosure, by the way, is in reference to the investigation that was done in Detective O'Driscoll's testimony. So, the court has yet to schedule a hearing to address this motion, and as for what's next for Kouri Richins, well, she faces some serious charges, including aggravated murder, attempted murder, fraud, forgery, all in connection with her husband's death, and if convicted, she could face a life sentence. Meanwhile, the focus shifts to her upcoming trial in April, with the next hearing set for 2 days from now to discuss jury selection. But that's all we have for you right now here on Sidebar, everybody. Thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. I'm Jesse Weber. I'll speak to you next time.